Hello, good morning. Thank you all for joining us today for the Lawyers for Learners presentation, Wisconsin Child Support 101. Please note that this presentation is being recorded. You can put any questions you have into the chat and they will be answered in the presentation if possible, or we do have time set aside to answer any questions at the end of the presentation. I am delighted to introduce our wonderful presenters, Jennifer Binkley. She is the director of the Family Court Clinic at the University of Wisconsin Law School, and Jill Kastner, an attorney with the Legal Action of Wisconsin. And we are so grateful for you being here to share your expertise today. So thank you so much. We also want to let you know that this presentation is for information only. It is not legal advice. So please reach out to your own legal expert or fill out the Lawyers for Learners intake form to be connected with that legal help. And with that, I'm going to pass the baton on to Jill to start the presentation.
Well, thanks so much, Katie. First of all, what I want to do is kind of let you know what we're doing today. Obviously, we're not here to train you how to be experts in child support law. We couldn't do that in an hour. We couldn't do that in a day. Instead, what we're going to focus on primarily is kind of issue spotting, determining the issues that folks may have with regards to child support issues, and then help you find the resources that would be necessary to guide that person to the proper resources and provide them with information that may be needed. Resources will be included at the end of the presentation so that you have that information and don't have to scribble down notes like a crazy person. Next slide, please. All right. So we kind of like to get some background information to know kind of who we're talking to and what level you may be at in regards to your current knowledge of child support. So our first poll question, if we could launch it, is pretty simple. Have you ever been asked a question about child support, whether it be from students, colleagues, family members? And if you could, do the poll and let's see kind of what folks are doing. And I'm going to give it a couple seconds for folks to respond. All right. And it looks like primarily, yes, folks have indeed already been asked questions. So some of you or most of you will come with somewhat of a base knowledge. All right. And then let's launch to the next poll. Where are those questions primarily coming from? Are you primarily getting questions from parents who have primary placement of the child, the non-custodial parent, the non-primary placement, often the person who's paying the child support, folks with 50-50 shared placement, or not sure? And if the answer is actually all of the above, hit not sure. And we'll give that a few seconds to get that results. All right. And we are all over the board with regards to that. So that's fantastic. All right. And now the final question. So we'll on to this poll. How equipped do you feel answering those child support questions? Is do you feel that you have a good amount of knowledge to answer the questions that get posed to you? All right. All right. So a lot of the majority of folks have said no, and that is completely understandable. And so next slide, please. All right. So a lot of the questions you are going to get asked is about receiving child support, paying child support, how to get an order regarding child support or changing that order, modifying it to make changes. Next slide, please. All right. So the good starting question, if anyone asks you a child support question, is there a current order in place? So there are different ways that couples do it, parents do it. Sometimes there's no order in place, in which case the starting point is, how to get an order. Other times there's an order already in place, and it's about figuring what's in that order, how to comply with that order, or how to change that order. So typically, if there was a divorce action, there should be an order in place. However, that order may not have a child support component to it. And so if they don't know for sure whether or not they have an order in place, one of the best places to check is CCAP. Now, of course, I say CCAP, and in some places they're like, oh, yeah, I use CCAP all the time. In other places, folks don't know. So if you could launch the next poll, is have you ever used CCAP to look up someone's record? And if you don't know what CCAP is, please do press no. All right. It looks like everyone has used CCAP before to look up records. That's fantastic. Next slide, please. All right. So if a student doesn't know if they have an order, check CCAP. And we have the website there, although everyone answered yes, they've used CCAP before. But please understand, CCAP is not the end all be all. So if there's a family court matter and a lot of paternity matters, it should be on CCAP, and it should note if there was a hearing, if there was an order, something like that. Just because you can't find a case in a paternity action doesn't mean that it doesn't exist. There are some paternity actions that for some reason are not on CCAP. So it's not a for sure that there isn't, but it's a good indication that there may not be an order if you can't find either an FA, which is a family matter, or a PA, which is a paternity matter. So FA would be they were married at one point, PA typically between non-married individuals. The other thing that CCAP can sometimes tell you is, if there's been a contempt order or something like that. Another way to answer the question of is there a current order, particularly when you're dealing with a non-primary placement parent, is do they currently have a wage assignment? Is part of their paycheck going to child support? If part of their paycheck is going to child support, chances are very, very good that there is an order, because that's how they're getting that garnishment right now. Next slide, please. All right. So we were going to leave open the possibility that we needed to kind of instruct folks on how to use CCAP. And just in case there was anyone shy who didn't want to say that they didn't know how to use CCAP, CCAP is the Circuit Court Access Program that's available online. We have the link earlier, and you can basically use it to name search individuals. So you put in someone's last name, first name. A lot of family and paternity actions don't have date of birth. But you can usually put in the county, and that'll help limit things as well. And basically look someone up on CCAP. But because all of you answered yes, that you did know how, I'm not going to spend too much time on that. All righty. So if there is no order in place, you can't find one, there's no wage assignment, they're not getting paid from a wage assignment, then chances are there is no order. So what do you do when there is no order? So if it's the primary placement parent, the one who has the child the majority of the time, they can request help from their local child support office. So as opposed to directing them automatically to like a free legal service organization, you should actually direct them to their local child support office. So below we have the information for Dane County, but there should be a local child support office in every county. So typically you can simply Google Milwaukee Child Support Office, Manitowoc Child Support Office, Brown County Child Support Office. And it should come up, and you can simply direct them to the office location. They can call in. Pre-COVID times, you could walk in, but at this point, we would often recommend that they that they call, or see if there's a link to services on the website. But in most counties, it's going to be a call. And then below is the information specifically for Dane County. Next slide, please. All right. If there is a court case, but there's no order, one, how could that happen? And what do we do if child support is not assisting? So let's say it's a divorce case and they agreed upon 50-50 placement, no child support, but that's not how it's currently working. One parent is basically doing all of the caregiving, and there's and now they want to change that. Or there may be a paternity action where, again, they agreed to 50-50 placement, or for some other reason, the primary placement person wasn't requesting child support at that time. If there is no child support order, they may want to go in and create a child support order. And there's a difference between no child support was ordered versus 0 child percent was ordered. If no child support was ordered, again, you may want to direct them to the local child support office. If child support was set to 0 and their local child support office isn't helping, that's when you want to direct them to either one of the self-help sites, or a free legal service provider. I would recommend that for most folks, directing them to one of the self-help sites is probably the fastest and easiest way to go. If you have reason to believe that they aren't going to be able to navigate these sites, then we'll have more resources that may be able to assist them. And so what we have here with this link below is basically the family court forms. Now, before we were talking about the difference between an FA case and a PA case. For purposes of this, the family court forms are the family court forms. And so those work for both FA and PA cases, but they're considered family court forms. And not only are there documents that they can use and fill out, and a lot of fillable forms that they can simply either type into or print out and write on them, there are instruction sheets as well, and all of those will be available at that website. Alrighty, and as a reminder, as questions come up as we go, feel free to put them in the chat, as we will be monitoring the chat. All right, next slide, please. All right. So how do we change a child support order? If there is a child support order, or the child support order was 0, or the child support order is too low or too high, how do we change that? So there are a couple ways to go about doing that. Obviously, if they can come to an agreement and want to do what's called a stipulation, which is basically we agree that this is what the new order is going to be, they would want to look at the stipulation form, fill it out together, and then submit it to the court. Usually the courts, if the parties agree, the court is going to agree. A lot of times, however, the parties can't come to an agreement. And so the party that wants the order changed is going to need to bring a motion. And again, those forms are online. We have the link specifically to the modifications to the change form that they can fill out. Be aware that the form has a lot of different things that they can change at the same time, and they may not want to change all of those things. So, for example, if they simply want to change the child support, they can ignore the part about custody placement and simply go to the place where it talks about the child support itself. And so that's what they're going to want to do. Another question that you may get is that they may not want to change, but they're being forced to make a change. So let's say the primary parent suddenly goes on food assistance or Badger Care. The child support office on its own may bring a child support order against the non-primary placement parent for support because they're now on some form of public assistance. And unfortunately, there really isn't much that they can do to stop that, so long as they are receiving benefits. Next slide, please. All right. Assuming the student wants to change the order, what are some of the factors that they need to consider? All right. So the first thing you want to consider is how long has it been since the last time they reviewed the order? If they just got a change 6 months ago, it's going to be very, very difficult to try to change that order. Usually what they look at is, has there been 33 months since the last motion was brought? And if it was, that may be a very good option, and they can show the circumstances to the court. But if it's less than that 33 months, there really needs to be a substantial change in circumstances for the court to really consider and reconsider the prior order. And there are lots of reasons for substantial change. One of the biggest one with regards to support is how much money is being made. So for example, if it was, some type of, placement schedule, and suddenly the student, graduated and went from making $20,000 a year to $50,000 a year, that is a substantial change in circumstances, and chances are good the child support is going to go up. Other substantial changes in circumstances are someone becomes disabled. Somebody may be incarcerated. Somebody may now be out of state. There are a lot of there are other ways that there are substantial changes in circumstances. Just be aware that if it's not past that 33 months, it's going to be on the moving party, the one bringing the motion. It's going to be their burden to prove that there was a substantial change. And going from making $11.50 an hour to making $11.55 an hour probably is not going to be considered a substantial change. Going from $11.50 an hour to $21.50 an hour, that could very well qualify as a substantial change. All right, I'm still not seeing any questions, so we'll go to next slide. All right, so now I have some questions for you. And so why don't we start with the first one? So we'll launch that so you can see the question. So non-primary placement parent, so typically the one who's paying into child support, graduated from school and is now making significantly more money. Is that a substantial change? We'll see who is all listening. Excellent. Everyone got the answer correct. Wonderful. You guys are paying attention. That is absolutely a substantial change in circumstance. All right, let's go. I'll launch the next one. So again, the non-primary placement parent has become a full-time student, quit their job, and now has no income. Would that be a substantial change in circumstances? And we'll give folks a second to think about that. So yes, that would likely be a substantial change in circumstance, the fact that someone decided to become a student. Now, what a court decides to do with the fact that someone decided to become a student, in my experience, has varied widely. And courts have been very accepting of it in some cases and not very accepting in others. But that is, suddenly going from income to no income can certainly be deemed a substantial change in circumstances. Now, whether the court is willing to reduce child support while the non-primary placement parent is in school, that is a different question. But typically, they will look and find that is a change in circumstance. All right, final question. All right. So one of the parents got married, and the new spouse makes a lot more money, significantly increasing that household's income. Is that a substantial change in circumstance? And so we have some variation here. So PP means primary placement parent. So so probably yes if it's the primary placement parent who suddenly has a lot more money. No, or probably no, if it's the primary placement who got married. So what do folks think? All right, give folks a couple seconds to answer. All right. And so, yeah, the majority got it right. Probably not. When taking into account child support, there are a lot of factors that the court can consider, but typically they do not consider the income of the spouse. So if you're dealing with the non-primary placement parent, and their spouse makes a lot of money, they don't make a lot of money, the court will not necessarily increase it based on the fact that they now have a spouse who makes a lot more money, but it can be a factor. And the same is true is let's say the primary parent got married and they go from basically a low income status to a nice comfortable status. Does that mean that the non-primary parent can pay less? And that is typically not um, a substantial change in circumstance. There are obviously always case by case situations where it may be, but often it is not. All right, next slide. All right, so the next set of questions is, will you actually get more money if you bring a motion? Well, that sounds like that may involve some math. And if there's one thing lawyers don't like, it's math. So I'm going to turn this over to Jennifer. Jen.
Hi, everyone. We can go ahead. Well, I'll go through a little bit of this. And I did see one question in the chat, and I think I'm going to be answering that as we go through these next couple slides, even though it was from earlier. So it seems like the right time coming up soon. So is the non-primary placement making more money? So that's possible, then, so when we're talking about primary placement parent, that means that the parent has at least 75% of placement time. Once we hit the magic number of 25%, that split, then it becomes a shared placement in terms of child support orders. And then we have a little bit of different math. So we'll talk about that in a little bit. And that goes to that question about like, why, if it's 50-50 placement, might there still be a child support order? So if the non-primary placement parent is making significantly more money, again, that substantial change, then certainly that could be a time to go in and request a support change. If the non-primary placement parent, you think they're hiding income, what kind of evidence are you going to have? Because that goes back to Jill's comment that it's going to be your burden if you're making that motion. So that can be a little tricky. And that's where you may want to get some more legal assistance if you really think that someone has, may self-employed. It's a really tricky one, even for lawyers, if they're paid in cash, things like that. But sometimes all you need to do is show what they're paying for things, because there's got to be money then, right? If they're paying bills and they're paying for expenses. So there's some options there, but again, tricky to do sometimes. If the non-primary parent is incarcerated or unemployed, two pretty different things. Unemployed folks are often imputed income of at least minimum wage, but sometimes based on their past employment as well, or oftentimes. There are also times when they'll get a period of unemployment where they won't have to pay child support, assuming they file a motion to modify. So, it can be, the courts could allow that person a little bit of time to obtain employment and set a very short period of $0 or held open child support. Incarcerated parents, more and more, especially in Dane and other counties, although some not, assuming either child support or the parent who is incarcerated files a motion to end or suspend their support, that will often be granted because it's just impossible to have income available to pay support while you're incarcerated. Now, there are certain exceptions. If you have investment income, if you have assets, there could be exceptions. And some counties just have decided that they're going to continue orders regardless, because it is an act of volition. You did it, you did something willingly, and that has affected your ability to pay child support. But because you made that choice, they will not suspend it. But that is not true. Like I said, in our county, Milwaukee County, other counties are routinely setting those at 0. And in fact, child support's initiating a lot of those changes here in our county when they see someone has become incarcerated, because it just creates a huge arrearage that can't be paid. And that's not ideal. So can we move on to the next slide? Okay, so we've got another poll question. Speaking of, I guess I kind of answered this. If the non-primary placement parent is incarcerated, do you think a court is likely to increase child support? But it does talk about, these different reasons or different things that might have happened. So let's see what people have to say about that. Let's see here. Give it a second there. There we go. Yeah, the court is probably likely to temporarily stop or stay or reduce the child support. It's usually not related to the crime itself. There's one exception. There is a charge for failing to pay child support that can actually become a crime, not contempt of court. It's super rare. So I think if you had a case where somebody was actually incarcerated for failing to pay support, that would not be a reason for stopping support. Something else is going on before that. It's like I said, contempt of court is really common and can result in someone being put in jail, but they're rarely charged with an actual crime of failing to pay support. And obviously that would be a little bit different. All right, so next slide. Okay, so you wanted the change in order, but will you pay more or get less? So we work with lots and lots of folks who have questions about changing their support over at our family court clinic. And we do get a lot of people who contact us, and we do some math with them, and they determine they do not want to file a motion to modify their child support, because based on the current circumstances, they're going to actually have to pay more, or they are looking to get more and they realize that based on the situation, they may actually get less, so they don't want to file. So first of all, has anything changed substantially? So if it's just like, I'm tired of paying this, it's really hard for me because, inflation, it's super valid, right? Like things are more expensive out there in the world. But if your income hasn't actually changed and the support's been the same, or your income's only going up a little bit, then that's or only gone down a little bit, that's probably not a substantial change. Is your income high enough for an income assignment that meets your current order? So some folks don't have enough money to pay for the amount that's being taken out of their check. And there's limitations on how much can be taken out. But it's a lot. It's like 50%. So if 50% of your paycheck is not enough to pay for an income assignment, that might be a really good time to file a motion. Sometimes you can request a low income payer adjustment if you're at the poverty level. So that might be, and that hasn't happened before, you could request that, especially, and I think the combination of, continued low income and, maybe your own expenses might be a reason to make that request at that time. So let's look a little bit more at the math. The next slide. So there's a link here for support calculators, and I believe that all of these, all the links are going to be provided to you after this, so you can give them a try. But they have calculators for low and high income parents, serial families, and shared placement. Now, when the question about if there's 50-50 placement, why would there be an income assignment? So there's a complicated mathematical equation that kicks in once you hit the 25% threshold. So once a parent has more than 4 overnights in 2 weeks on average, or about 96 overnights in a year, they become a shared placement family. So if it's not, then it's just a percentage standard, and we'll show you that in the next slide. But what happens is, to figure out these amounts, you first use the percentage that each parent would owe in support for their children, which is a little bit funny. So each parent in a shared placement calculation is actually a payer. And then what you do is you do some math, you multiply by 150%, you offset how much placement each parent has, you come up with 2 amounts, and then whichever is the higher is offset by the lower, and then that person is the payer. So again, I could go through it all, but essentially it would, if you had 2 children, you'd be paying 25% of your income. One parent makes $2,000 a month, one parent makes $4,000. You would have $500 for one parent, $1,000 for the other. You do this other math of 1 times it by 1.5, and you do some subtractions. And I think you turn out about, a $300, for example. I'm not sure if that math is right, but of the higher income parent paying the lower income parent. So it would, now, if you had the situation where the parent with the $4,000 a month income had very little placement, they would be paying $1,000 a month in child support. So it's sort of a phase out. And interestingly enough, you could have a situation where a parent has 74% of placement, let's say. They could actually have a child support order or an amount that they owe the other parent who has very little placement because of the math, if they're a much higher earner family or individual. All of that said and done, once you have shared placement, you also have shared variable expenses. So you're also required to share in the cost of things like childcare and extracurricular activities and braces, and other things that braces might fall under medical, which would be shared regardless. But I just like to note that it's not, when you pay full child support, you don't have those extra payments that are owed. So a lot of times it all comes out in the wash. Someone had a question, if a parent has 2 kids with 2 different moms. So then you are a serial family payer. So what happens is what you pay for your first child, whether it's an intact family or an order, gets discounted from your income available for child support. And then the next order is taken from your lower income. So again, going back to the individual who makes $2,000 a month, he has 1 child, there will be a $340 support order attributed to that child. So his income available for child support will be the $2,000 minus the $340. So it'll be $1,660 available for child support for the next child. So the next child will receive a smaller support order. But as you can see, these start adding up. So you do get a discount, but you don't get a tremendous discount. So it still is a considerable amount of money once you start having more than 1 child in different families. The percent does go up when you are in the same families. And someone had a question about, they just reviewed right. So if you go back and you're modifying your oldest child's support order, there won't be anything taken into account for your other children, because the first child will take precedent and get the largest support order. So it doesn't go the other way. It only applies to the children who come next in line. And then, of course, when the oldest child reaches the age of 18, then that or 19 after, if they are still in high school, then the support order would change at that time to the full amount for the next child, and so on. Okay, so let's go to the next slide and see what those percentage standards are that I've just been talking about. So 17% of gross income for one child, 25% for two children, 29% for three children, 31% for four children, 34% for five children or more. The question is, how do you figure out if the youngest child is getting too much? You just have to go look at the support order for the first or oldest child, reduce the income by that amount, and then do the math. If you think it's wrong and it's already been set, you'd have to file a motion to get it changed. I would just like to note, though, obviously, if you have two children from the same family, you're going to be paying 25% of your income. If you have two children from two different families, you're not going to be paying a full 34%, but the amount you pay might be different because, again, you're paying another 17% off of your reduced income. So it doesn't work out quite to be that same percentages. So that might confuse people a little bit, but it's a little bit different. So let's go to the next slide. So this is a big reminder. A lot of people get questions or they're upset about their arrears balances owed and they want to file motions to reduce those. Arrears payments cannot be erased or reduced unless the party owed the funds agrees. So that can be either the state of Wisconsin, which is represented by the county, or the individual parent who's owed the money. So going back to our earlier slide where we had that stipulation to amend a child support payment, that can be used to amend an arrears balance or the arrears payments as well. That's an option on that form. So that's basically your only way to go on that. The exception being you can reduce the amount you pay each month if it's untenable, if it's just something you can't pay, if it's too high, then of course it will take you longer to make the payments on your arrears. But sometimes it just can't be done. So you can file a motion to deal with the amount you pay on the arrears each month. You do pay interest on the arrears. So what happens is when you make a payment to child support, it goes to your current order first, and then it goes to pay on arrears. It's simple interest, so you are not paying interest on the interest. Excuse me. So we can go to the next slide. So this question is, excuse me, I'm just going to mute myself for a sec. I had a trial the other day and I still haven't recovered my voice all the way. Too much talking. So how long before a motion is heard? So it's usually about 30 days, but the order can be modified to the date of mail service, but not any date earlier, which is really important because going back to those arrears or anything that you've paid, if you don't file a motion, nothing's going to be changed. There are some rare exceptions related to fraud. I almost don't bring those up with people because people always say that happens in their case, but it's super rare and unusual. I want to point that out. But generally, so then it'll be possible, it's permissible and it's allowable to backdate the order to the date of notice of the motion, which is basically 3 days after it's mailed. Sometimes the court will decide to change it to a later date, but they certainly can put it to that date. And that's good because there could be delays caused by the other side. They could ask for rescheduling. They could ask for more time for a lawyer. And all of that would limit the amount of time that you can get that order changed from. And again, since you can't get it from before the motion, that's important to remind people if they want to change, they need to go in and they need to make a motion to the court. Some people get confused because they've heard from child support about possible changes. They had to file updated financial information directly to the child support agency, perhaps after that 33-month period. But unless a motion's been filed or an order or stipulation has been entered and then an order, then there won't be changes to the order and there can't be changes until those things happen. So it's really important to remind people of that. It'll initially be heard before a court commissioner. If it's a contested case and not a stipulated, either party can request by a review by the judge. That's a de novo review. You need to attend that hearing to preserve this right. Otherwise, it's going to be a default order, and that cannot be de novoed. But if you show up or have a lawyer appear for you, you can then request that the court review it. And it's just like a brand new hearing, and there is no, it's not an appeal. It's just a do-over, essentially. All right, next slide. Contempt actions. So if the child support agency is a party, they may file an enforcement action if the payments aren't made, or you can file your own contempt motion. So we included those forms. Contempt motions do need to be personally served, or the person has to admit service and sign a document saying that they did. Unlike a motion to change, which can be served by mail. You are entitled to an attorney if a contempt motion is filed against you. So please let people know that. And the income limits for that public defender option are a little bit different than they are for other, like for misdemeanors and felonies. So for child support. So make sure that they at least reach out unless they can afford, and do say that they can afford an attorney. But often folks who are have contempt motions filed against them are unemployed or underemployed, or just getting out of jail, for example. So they would qualify. So I highly recommend doing that. The public defender can only help with the contempt, and they can't help with filing motions to modify, though. So, good that you have that other information for them. As a reminder, anytime someone files a motion to modify, anytime someone is going in on a contempt motion, they should also file an income and expense form, which is also on the same website with the other forms that we have, and is mentioned in the forms themselves to show proof of income. Also, if you have a W-2, pay stubs, anything. Although unemployed people have very little, they should still fill out the form, even if they don't have any proof of income, because they don't have income. There's also a financial disclosure statement, which people are welcome to use, but it's not required in modification actions. It would be required in setting an initial support action, though. So it's a lot longer form, and I don't instruct people to do it necessarily unless they have to, because it's just more burdensome than the 2 or 3 page income and expense form. Again, all the forms tell folks to do that, so it's not something you need to remember on its own, but just go through the form and you'll see that those instructions are on there. Next slide. I think we're getting close to the end here, so I can go back to questions too. So these are all great resources that can help people. We have our Family Law Assistance Center, which is at the courthouse. It's a walk-in program. So you just go down to the basement of the courthouse, the lower level. I think we've been in the law library. Sometimes we're in a separate room, but it's always down in the basement. My Family Court Clinic, you can call and make an appointment. We will be closed for a while during our break before summer starts again, and then we'll have other breaks when school is not in session. There's an online Wisconsin Free Legal Answers where someone can post a question and get written help, maybe forms back to them, things like that. The Madison College Legal Clinic is another option. There's a website to request an appointment. The Public Defender's Office, which we already talked about. Dane County Child Support, again, can be of assistance, especially if you are receiving or your child receiving public assistance. The Urban League of Greater Madison has what's called it's like the fatherhood program, but mothers can get help as well to get assistance with the forms, to get connected with someone from the Family Court Clinic, and also at the same time, perhaps connect with an agent from the child support agency to find out more information about what they owe and on what cases, because it can get really confusing. Legal Action of Wisconsin and Community Justice at the bottom for, I would say, both those things for more complex litigation, or Community Justice, when we mentioned things about hiding income, they do charge fees for a lot of their services, but they're reduced. And other attorneys, we only put either free, reduced, and nonprofit because we can't refer you to other attorneys. but you can contact the state bar lawyer referral and get connected with an attorney if there is income enough for you to hire an attorney and you think that would be advantageous. So those, and I see a couple other questions that if a dad loses his overtime after the new order, sure, that could be if the overtime was considerable and was part of the other order. If it's just that the overtime was always extra and helped them pay a support order that was not based on the overtime, then I'm not so sure. So you'd have to take a closer look at that, I suppose. The original order and what it was based on. You can do some reverse math. And the order itself should also contain information about what the parents' incomes were at the time they set it. So that will be in the order itself, the written order. It won't be like on the child support website. It won't be on your bill, but the actual court order will contain what the income was that the support order was based on. So you want to see if that is now different. If it's not, then you're going to have a little bit harder time. Even though it's a change in your circumstance. It's just, they're going to say, well, you should have reported your overtime and had an increase, and now you're just going back to what it was before. Should I seek 50-50 placement so I don't have to pay child support? Well, for one, it might not eliminate your child support, and you may have to owe a whole bunch of other bills. So think about that math, I guess. But as a reminder, the statutes definitely state in Wisconsin that child support is not a factor in making placement decisions. So you have to have really good reasons to make that placement change that have nothing to do with child support, or you will not get very far. And you need a substantial change regarding placement factors rather than child support. So you're going to need that to file that motion. So again, and you can end up paying financially, it might not be advantageous to you as well. I just want to point that out since it's so complex in how those payments are ordered, and that there will be another additional financial obligation once you are into that shared placement world with the variable expenses. And ultimately raising children is expensive. So whether you're doing it and paying it in your household, or whether you're giving somebody else some funds to pay for those things, it's expensive. So, there's only so much you can do about how both parents are going to be obligated for those expenses one way or the other. Once the child turns 18, I don't owe anything anymore, right? Well, maybe. So if your child graduates or is no longer part of a program to receive a high school degree, so enrolled in some sort of program towards a high school degree, the child support order will continue until they turn 19 if they're enrolled. At that point, it should stop. If you only have one child, you'll receive information saying, we assume the child support is going to end on such and such a date. Please show us that the child is still enrolled, and then it will continue if so. So there's something like that you'll receive notice of. Just to cover your bases, you might want to file a motion to modify, though, if you think it should be ending. I will say, though, if you have other younger children in the same family, nothing is going to happen on this case unless you file a motion to modify. There will be no assumption of a specific change in the amount that you owe. You could actually owe more at that time because perhaps incomes have changed, or there is other circumstances that have changed. So the court doesn't know that until you present them with the facts. All they know is that you have a child support order, and it's for multiple children. So you need to file that motion if you think that because your percentage has changed, your amount that you owe based on your current income is also going to change. But don't forget to go back to the other slide we had, which says, do I really want to file this motion? Because maybe you have had changes of income and you've reported them, and the other parent has just said, I don't really want to file a motion. I'm fine with what I'm getting right now. You file that motion and you open up all the cans of worms. So, but it could be that, yes, you owe a lot less because your child's turning 18 and is no longer going to be covered by child support, and you have only one younger child. So, sort it out, and then definitely file that motion if you think you're going to get a lower amount. mom lost custody and the kids are in foster care. Why am I still paying support? You're still paying support because the children are in someone else's care than your own. So that those child support payments should be going to pay to help offset the foster care costs. And those costs might be then owed to the state and represented by the county. So going back to how do you get those changed, you're definitely going to need, or the county's going to be involved in any of that going forward, and any arrearages owed will be to them. And so they would have to agree to any, removal of them or any lowering of them. So the PowerPoint will be available. And the question about, are there attorneys that can help? We provided those resources. So those are legal resources you can reach out to if you want more assistance with filling out forms. For example, the Family Law Assistance Center has free attorneys who can help you with filling out forms and give you limited legal advice. The Family Court Clinic has students who can help you with forms and information, but not advice. So those are some options, as well as the State Bar.
I'm sorry, go ahead.
Oh yeah, I see another question. What happens when arrears once the child turns 18? They collect interest at the same rate they always have. They never go away, ever, ever, ever. They cannot be discharged in bankruptcy. They will be potentially part of your estate. I have gotten, they don't, then there are, exceptions to that and things, but there are, they don't go away. So you will have to keep paying them unless you can get the person who is owed them to agree to reduce or eliminate them, just like any other debt. It's except for that you can't discharge it in bankruptcy. So it's maybe like student loan debt, even harder actually. So it depends if they're enrolled in a GED program. It might still count as up to the 19. So you'd have to look at the specifics of it. But if they're just like, I'm going to take the GED test and I'm doing some classes online, I don't think that's going to qualify. But I know there's different kinds of programs regarding that. So and that, then you'd have the 19 or receive the degree, 19 years of age. Okay, so that's all the questions I saw in the chat, but did anybody else notice any that I missed?
Well, I would just add to the arrears question that if there was an order as to an arrears amount after the child is 18, and if it's the only child, the support order will end, the arrears order will continue, and it will continue at that level. But because interest is accruing, someone may actually want to pay additional funds to kind of stave off that interest. Otherwise, they're going to be paying that out of their Social Security check.
Right. Yeah, and someone asked, does it end at 19? Yes. So if there's still, for example, if you have a child who's disabled, they can stay enrolled in public school until I think the age of 21, but their child support order would actually end at age 19, which doesn't necessarily seem fair, but it would end at that point. And going back to Jill's note about the arrearage that you may want to pay more, so you can start, getting those down. Also, the person who's receiving the funds could file a motion and ask for an increased amount, because now you're not paying current support and they might want their money faster rather than slower. Even if they're getting interest on it, they may just, want it paid off. So that's also something that could happen. Going back to that amount you pay on arrears can be modified. Anybody else questions?
Well, we can't thank you enough, Jennifer and Jill, for taking the time and your expertise to share with us today. The handout is available. We'll make the PowerPoint available along with it. And then there's also, we're going to record this. So if you know of anyone who weren't able to attend today, but this would be great information for, we'll make sure that you all get that link as well. So I hope you have a wonderful day and the rest of your week. And thank you all.
Thank you, everybody. Have a great day.